After the death of the deceased employee, she remarried.
Huh?
She again married, Your Lordship. She had married in the year 2004. Out of the said married, child was born. These facts were concealed while getting the compassionate appointment.
She was appointed on compassionate ground.
On compassionate ground,
Why inquiry has not been held?
in fact, the
So
reason,
principle of natural justice, the
in fact,
holding of inquiry,
if
is she a regular employee or not?
she was a regular,
Then a regular employee means CCA rules are applicable or not?
Your Lordship, on the last occasion, the
in pursuance of the last order, Your Lordship, I am highly encountered. Although the record of the case is with me, Your Lordship.
Lordship, my humble
Where
submission.
is the original application filed before the CIT?
Your Lordship, there was no proper departmental inquiry also. On that point, the matter was asked for to be listed today.
No,
Yeah.
what is the punishment?
But I have been terminated from the service. There is no proper inquiry, not at all.
Where is the termination order?
That is Annexure 10, Your Lordship.
Huh?
Annexure 10 at page 50. लास्ट लाइन आपकी रेल सर्विस तत्काल प्रभाव से
Huh. This is up.
रेलिवेंट एट पेज 51.
This, he says this is done.
वही जो नहीं लिया।
Annexure 10 is not the termination order.
यस लॉर्डशिप, दैट इज लास्ट लाइन, आपकी रेल सेवा तत्काल प्रभाव से समाप्त टर्मिनेट की जाती है जो आपको पद हस्तगत होते ही प्रभावी हो जाए।
10
ये
एनेक्सर 10 से पढ़ रहे हैं।
एनेक्सर 10 का पेज 51 का लास्ट लाइन, पेज 51 दिखाई।
There is no page 51.
No, in the repetition. Again,
पेज 51 के लास्ट लाइन, आपकी रेल सेवा तत्काल प्रभाव से समाप्त टर्मिनेट की जाती है।
Show notice by this one, reply by explanation. Explanation.
she is a regular employee. And the post. She was appointed on compassionate ground.
On compassionate ground,
Why inquiry has not been held?
on the, may I kindly submit, Your Lordship? She procured the appointment on the basis of wrong information and concealment of information. After the death of the deceased employee, she remarried.
Huh?
She again married, Your Lordship. She had married in the year 2004. Out of the said married, child was born. These facts were concealed while getting the compassionate appointment. When the second
So
husband,
compassionate appointment was sought on what date?
it was sought on, Your Lordship, 2/11/2015. She filed an application before the concerned authority.
Huh.
And the employee died on 9/11/2001.
No, termination is in the year 2021.
No, Your Lordship.
Huh? Termination is on what date?
That is
Termination, Your Lordship, 5/8/2021.
5/8.
So for the last 5 years she has worked.
No, complaint was made in the year 2019.
Correct, sir.
She was
2016 appointment.
2017 appointment.
17. All right. Even thereafter, 3 + 1, 4 years she has worked.
In the year 2019, a complaint was made by the.
Sir, hold an inquiry, sir. You can't terminate in this fashion.
In fact, I am relying on Supreme Court judgment, Your Lordship, which says
Inquiry is not required.
inquiry is not required. Not even a show cause is required if a person obtain an appointment under compassionate ground by concealing facts, Your Lordship.
She has been given appointment after inquiry.
In fact, she was asked a show cause.
These are all old matters, sir. Subsequent decisions are there.
In fact, the
So
reason,
principle of natural justice, the
in fact, the
holding of inquiry,
if
is she a regular employee or not?
she was a regular.
Then a regular employee means CCA rules are applicable or not?
In fact, in the appointment letter itself says that if she concealed any information,
Where is it?
while get,
Probation period declared as satisfactory?
Probation period was for 2 years, Your Lordship.
That is declared as satisfactory. Therefore, she is a permanent employee. In the result, CCA rules is applicable.
That is there, Your Lordship, but the
So you have to, no. We'll distinguish.
in fact, an inquiry was held. 2 persons were examined. 2 persons.
Sir, where is the article of charge?
There is no.
In fact, a proper departmental inquiry was not.
To hold a departmental inquiry.
That is an admitted fact, Your Lordship. But a detailed show cause was asked from her. She replied by conveniently
Sir.
stating the main.
Sir, come. She is rightly or wrongly appointed. Her probation period has been completed and she is a permanent holder of the post. For the purpose of permanent holder of the post, CCA rules are applicable. Invoke CCA rules and frame charges.
In fact, I am, Your Lordship, relying on this judgment, but the concealment of fact while getting an appointment required no show cause in fact. This is what has been held by the Honorable Supreme Court.
Yes. Yes, take down. The instant writ petition, petitioner has assailed the order of the CAT dated so and so, filed in OA 50 of 2022. Petitioner's husband was working as a Kalasi in mechanical department of Samastipur division, Eastern Central Railway. He died on 9/11/2001. Who is the petitioner filed an application for compassionate appointment and she was appointed on compassionate ground in the year 2017. Respondents were stated to have received a complaint against the petitioner that after death of her husband, she was remarried in the year 2004. And it was not disclosed in the compassionate appointment application. She has also not disclosed certain material information for the purpose of claiming compassionate appointment. Taking note of such complaint, respondents proceeded to issue a show cause notice and on receipt of a reply proceeded to terminate her services. Feeling aggrieved and dissatisfied with the order of termination, she has invoked remedy under section 19 of the Administrative Tribunal Act 1985 in filing OA number so and so, dated so and so, OA number so and so, year so. CAT rejected the petitioner's original application while taking note of dates and events. Even the CAT has taken note of the alleged furnishing of false information at the time of obtaining compassionate appointment. Next paragraph. When counsel for the petitioner vehemently contended that petitioner was appointed in the year 2017 and he was on probation. After probation period was over, he was a regular holder of the post in the railway department. If any misconduct committed by her and the same is required to be examined in that event, a relevant rule would be railway servants rules, you put the title 1968 Full stop. Applicability clause of railway rule reads as under. Railway Rules 1968 reads as under. Having regard to the fact that petitioner is a permanent employee of the railway department, she is entitled to she should have been subjected to disciplinary proceedings under Rules 1968. The same has not been appreciated by the CAT. Hence, impugned termination order and order of the CAT dated so and so passed in OA number so and so are liable to be set aside. Per control and counsel for the respondent resisted the aforesaid contentions and submitted that the appellant, the petitioner has suppressed material information at the time of joining service on compassionate ground. Having regard to the contract, the petitioner is not entitled to continue in service. In this regard, learn counsel for the respondent cited so and so decisions. Heard the learned counsels for the respective parties. Petitioner was appointed on compassionate ground in the year 2017. Her services were terminated in the year 2021. The meanwhile, she had gained the status permanent status in the railway department. In the result, if any misconduct is committed by her, she should be subjected to inquiry under the Rules 1968. Rule 3 of Rules 1968 reads as under. In the light of aforesaid statute, respondent should have resorted to initiation of inquiry against the petitioner while invoking various provisions of Rules 1968. On the other hand, they have resorted to only issuing the show cause notice and proceeded to terminate her services. In other words, respondents have resorted to short circuit methods, terminating the services of the petitioner. Next, the cited decision do not assist the respondent for the simple reason that the petitioner had a status of permanency in the railway department. If any misconduct is committed by her at the time of joining service, it amounts to misconduct. In the result, Rules 19, the provisions of Rules 1968 is attracted. Therefore, the cited decision is distinguishable having regard to the facts of the case. In the light of these facts and circumstances, the petitioner has made out a prima facie case so as to interfere with the order of termination dated so and so, read with CAT order dated so and so, passed in OA number so and so. They are hereby set aside. The concerned respondent is hereby directed to regulate the intervening period from the date of termination till reinstatement as a duty for all purpose. Arrears of salary shall be calculated and disbursed in her favor. The present order would not come in the way of initiating inquiry under Rules 1968 and complete the proceedings within a period of 6 months from the date of receipt of this order. With the above observation, writ petition stands allowed in part.
Obliged, extremely obliged.